5, 4, 3, 2, 1. We are live. A very good morning to all of you. It is a pleasure for me to welcome all of you to the 25th SCOPE webinar. Even in the most difficult and trying times, SCOPE has continued with its endeavor to bring authentic and appropriate knowledge to your doorstep. While on one hand, we have tried to build capacities on arrow subjects, equal impetus has been given to health and well-being. In continuation of our effort today, we bring to you the webinar on one of the most pertinent subjects in the present times, legal succession, wills, nominations, and inheritance. While planning for one's family has always been of vital importance, but the significance has further been amplified with the pandemic, especially the second wave. The devastation and the stress that it has caused, especially for the surviving kin, has been very disturbing. In this light, SCOPE thought it pertinent to organize an interactive session so as to share relevant and accurate information so that planning for families can be done in an organized manner. To guide us through the various complexities of legal framework, we are honored to have an esteemed panelist with us. We have the pleasure to have with us Honorable Justice Rajiv Sai N-Law, Delhi High Court. Honorable Justice is presently the judge of Delhi High Court and has delivered many landmark judgments in his judicial career. Sir was elevated as the Delhi High Court judge in 2008. Honorable Justice initially joined the field of law in a solicitor's firm for 3 years and thereafter practiced law in the Delhi High Court and the subordinate courts, mainly on the original side in the fields of real estate, family, civil, and arbitration laws. We welcome you, sir, and are indeed honored with your presence. To have with us, we also have the pleasure to have with us Senior Advocate Akshay Makhija ji. Advocate Makhija ji started his practice in the chambers of Arun Jaitley and has been actively pursuing litigation practice in the Supreme Court of India, the High Court of Delhi, and various tribunals and commissions since 2000. Sir was the standing counsel for the Union of India till March 2021 and was also the pleader for the Union of India in the Delhi High Court from 2000 to 2006. His areas of specialization include commercial, contractual, and property-related disputes, and disputes related to succession and division of estates. Thank you, sir, for making time for us today, and we welcome you. We also have the pleasure of being joined by Advocate Renu Gupta. Ma'am is an experienced commercial litigator with more than 13 years of experience in dispute resolution. With expertise in commercial arbitration and litigation, ma'am regularly represents corporate clients and government bodies in commercial litigation and arbitrations as lead counsel as well as junior counsel before several courts and tribunals in India. Welcome, ma'am, and thank you for coordinating the webinar today. We also have the pleasure of being joined by an eminent leader of the industry today, Shri Ratna Sekhar Adhikaji, Chairman and Managing Director, Barman and Laurie Company Limited, and Executive Board Member of SCOPE. Handling multiple portfolios, Sir has an extensive experience in multicultural organizations in human resources management, industrial relations, and administration, only to name a few. Sir is a keen strategist, and the flair for designing and implementing innovative strategies and HR interventions in line with industry standards has been commendable. We welcome you, sir, today, and thank you for making time for the webinar today. We are also joined by Director General SCOPE, Shri Atul Sopti. Sir is a visionary leader having a versatile experience of nearly 4 decades. Before leading SCOPE as Director General, Sir was CMD BHEL, a Maharatna public sector enterprise. We welcome you, sir. Before we move further, I will take a quick few minutes to run through the interactions modalities. The participants joining live can put in questions in the question tab given in the Zoom platform. People joining us through social media platform can put the questions there, which will be taken up during the webinar. Now may I request DG SCOPE to kindly give his opening remarks for the webinar. Over to you, sir.
Thank you, Smriti. Honorable Justice Rajiv Sai N-Law ji, Senior Advocate Shri Akshay Makhija ji, Madam Advocate Renu Gupta ji, my colleague Mr. Adhika Sekhar, Chairman Barman and Laurie, all the participants here, ladies and gentlemen. It gives me somewhat relief today and pleasure also while interacting with you because we are meeting after a long time in somewhat normal environment with slight positivity in the country, as the number of cases of COVID, they are stabilizing and falling down. However, still the fear and the cautiousness among the people still remains, and we need to be very, very careful in this regard. In fact, the second wave, as all of us are aware, had hit us very, very hard. And for some, it had caused emotional stress and devastation. And also the magnitude, which do not think we have ever seen, or which has ever seen in during our times, or it has ever afflicted on mankind. So adding to the pain of losing the loved ones came the stress of losing an earning member. And this was combined with the little or no knowledge on the succession and the legal formalities of wills and nomination. This was a very difficult time, and such scenarios were not rare. While surviving kin had no knowledge of how to proceed with the assets claims, changing of bank account holders, whether they have any stake in the properties or not, how to go about the transfers and compilation of monetary investment, and many more related issues. And we take the things for granted, and we never prepare ourselves for the uncertain times. That's the reality. And in such a time, when families are already distraught with grief, and they have to deal with these complications and complexities of the succession and inheritance, and there is no clear documentation in this respect. So the mounting stress can only be imagined. We know live cases in this regards. Many of our nearest and dearest, our friends, they have faced this problem. So we at Scope, we thought it pertinent to organize an interactive webinar with the intention of providing easy tips, or you can say sort of the checklist, where after knowing the vital information, people can be educated on simple steps to secure themselves and future of their nears and dears. So takeaway after this particular program could be that we have a broad idea what needs to be done to be prepared for uncertainty in our lifetime or afterwards also. While at Scope, we have always been in the forefront of providing capacity building initiatives in a number of subjects, whether HR, finance, technology, information technology, corporate governance, etc. But distressing cases due to the lack of knowledge and guidance, as I mentioned on the succession, made it imperative for us to optimize our platform to create the awareness on this subject. Hence, we are organizing this 25th webinar, and we have planned it to understand the legal formalities better, which otherwise are considered as more personal in nature. So kindly make use of this opportunity. And we are really very honored to have with us our Honorable Judge Rajiv Sahe. And Laji, thank you very much, sir, that you have spared your valuable time. And Honorable Justice Saab, he is a well-known person for his great insight and extremely balanced judgment. Once again, I would like to welcome him, and he would provide his valuable guidance in the area of the subject which we are going to discuss today. We are also privileged to have with us Senior Advocate Shri Akshay Makhija ji, and we thank you once again on behalf of Scope. I'd like to welcome you and look forward for your valuable insights, thereby simplifying the law for us to follow and understand. And it's also a pleasure to have with us, Advocate Renu Gupta ji, with whom I have been interacting from quite some time, and we are now considering her as a part of Scope itself. And without her support, this particular webinar for today could not have been realized. And thank you, Renu ji. Thanks a lot. So today we are also joined by people from across the country. Many senior people are also there. Directors are also there. Chairman and managing directors are also there. Very senior officials are also there. And across the country, across the organization, they have joined us through the social platforms also. So we look forward to the eminent panelists for providing us with the comprehensive guide and actions to be taken today for securing tomorrow. And as I mentioned, that participants should make use of the available opportunity and feel free to address your concerns. But one word of caution is there. Please do refrain from asking legal opinion on this platform. So looking forward for an interesting and intriguing session. Thank you. Thank you very much. Over to Smriti.
Thank you, sir. Thank you so much. Now may I invite Advocate Renu Gupta ji to set the context for today's webinar and take the discussions forward. Over to you, ma'am.
Thank you, Samriddhi. Good morning, everyone. Mr. Sobti has elaborated upon the context of issues like will, nomination, guardianship, which have arisen given the background of COVID-19 pandemic. COVID-19 pandemic has brought trying times for families across the world. As per the WHO report, there have been approximately 42 lakh deaths as on 28 July 2021 globally, while in India alone, there have been approximately 4 lakh deaths as on 30th July 2021. The data from National Commission for Protection of Child Rights reveals that more than 9,300 children in India have lost one or both parent or were abandoned during this time. This crisis has given an unfortunate new term in the dictionary as COVID orphans. It is in this background that we will be covering topics today, such as the importance of writing a will, how to go about it, what are the principles of testamentary succession, how to provide for guardianship of minor children, and how to plan for property and assets of minor children. Having seen this reality of uncertainty of life, I would request our esteemed panelist, Justice Endlaw, to perhaps talk to us about what is the right time for making a will. This is one thought which is on everyone's mind. I mean, do you need to be of a certain age to start thinking about writing your will, or is there no better time than today to start thinking about it?
And thank you, Renu. There is a common myth that will is associated with old age or with certainty or uncertainty of life. What, according to me, is the correct position is that since the will is how the property is transferred or dealt with after you, so the concept of will should be associated with an asset. So whenever there is an asset, there should be a thought that there should be a decision taken. Again, I am not saying that it's very important to make a will, but what one has to take a call on, maybe otherwise the laws of succession are quite generally well known amongst the people. So if you are clear, well and good, otherwise take an advice that, all right, I have this asset now. Now, God forbid something were to happen to me tomorrow. What will happen to this asset? Who gets it? So that is the situation according to me. So whenever anyone acquires a will, for instance, even if a minor acquires an asset, even if a minor acquires an asset by inheritance from father or grandfather, a thought should be given to the fact that how will this asset be dealt with after the minor? And of course, the minor cannot make a will, a minor child less than 18 years of age. But a lot of times what is seen is that that escapes attention after the person attains majority also. So there are a large number of cases in the courts where, for instance, the most common context in which it happens is that the father, who is the owner of the property, passes away without making a will, and it's a residential house, and he leaves 2 or 3 children and a wife. And then a lot of cases, because under the law of intestate succession, if suppose it's a one residential house, let's take example of a 3-bedroom house, it will be inherited by, if his mother is alive, the male's mother is alive, one share. We are talking in the context of Hindus. Again, just some clarity on this aspect. Unfortunately, the personal laws are not codified as yet. So our what governs our personal laws is governed by our personal laws. What governs our personal affairs is governed by the personal law. So it may vary from faith to faith. By and large, there are three sects which are there. Hindus, which takes within its ambit Sikhs, Jains, Parsis, and then there is the Muslim and then the Christians. So these three are the largely broad areas in which we can divide. So one has to decide according to that. So I was talking in the context of that example which I was giving, that a male dies leaving a mother and then leaving a spouse and 2 or 3 children. Now, when the mother passes away, nobody thinks at that time that it should be taken from the mother. When the mother of the male passes away, a lot of times the property then goes to all her heirs, which may include the male's brothers and sisters. So the house which was supposed to be a residential house of the family, somebody gets a maybe even if it's a 1/10 or a 1/11th share, because after the mother of the male passes away, she may be having 4 or 5 children. So everybody, 4 or 5 people will get an interest. And so if her share was, say, in the case of 2 children, so her share would be 1/4. So her 1/4 share would be divided into further 4 or 5 shares. Then a lot of times it may happen that one of her other child also is no more, who has died leaving another daughter-in-law and a wife and children. So then each of them also gets a share. So over a period of time, this causes a lot of problem. So this is one aspect of it. The other kind of cases which we see are that where the one of the child gets a share, where we were talking of, and that child then after he gets married, there are differences with the spouse, so he wants to separate. So it all results in disruption of that residential house which was bought and of all members going out. So that is why, in my opinion, the call for making a will has to be taken the moment you have an asset, whether by acquisition, by purchase, or by inheritance, or by gift, or in any other manner. So that, and if you are sure that all right, you want to leave it in the manner in which the law provides in the absence of a will, then it's all right. You need not make a will. But if you want to make a change, even if the male's mother is residing with the male, but he still wants that, all right, since I have bought this house should go to my wife. Generally, it is better to, if the children are minor, to leave the property to the spouse so that she can take a call later on. At least nobody is disturbed from the house. So those kind of personal decisions have to be taken, that how do you see the property devolving and whether you want to interfere in the devolution according to law. Thank you.
Thank you, Justice Endlaw. If I may invite Mr. Makhija to perhaps give us his thoughts on the same question.
Taking forward from what Justice Endlaw has said, there is actually no right time to make a will. I think everybody should make a will the moment they acquire an asset, as Justice Endlaw said, and it's not just about immovable property. You also have movable properties. You have bank accounts, shares. People tend to have mutual funds, set up SIPs. So all that also needs to be taken care of. So I would say the moment you attain majority, you must make a will. You can probably think that, once I'm older, I have children and I'm settled, then I will make my will. But the thing about a will is you can always change your will. It's your last will that is valid. So you must make wills which are relevant to the present point in time in your life, which you are always free to change. And another very important thing along with wills is in your movable assets, you must make nominations. Because, and I'm saying this even from personal experience, where there is a nomination, things flow very, very smoothly with banks, mutual funds, all authorities. But if you don't have a nomination, you will be running all over the place to get that money out of the financial institutions. So along with the will, equally important is nominations.
Thank you for that. On the nomination aspect, if you could tell us perhaps about, there are often cases where you have nominated someone, but then in the will, instead of talking about those assets individually, you have bequeathed everything to a particular legal heir. So in scenarios like that, would the nomination made in the favor of Mr. X prevail, or would it be the legal heir, and how should people deal with situations like that?
A nomination is not a bequest. They're two entirely different concepts. A nomination is done for the purpose, essentially for ease of release of that asset from the financial institution where it is. Because a financial institution is not liable once it releases the funds to the nominee. So it is essentially something in place for you to get the money released from the financial institution where that money is invested. But a nomination does not create a right in that property. The nominee holds it in trust for all the legal heirs if there is no will. And if there is a will, then it has to go to the person to whom it has been bequeathed. So a nominee is actually holding the property in trust for the actual beneficiaries. It is just essential because you don't want your money stuck with the bank for a few years before you can actually access it. Because after someone passes away, there may be instant funds. There may be various expenses that need to be met. But if it gets stuck before you go to court, apply for a succession certificate and all that, it does take time. As fast as we may try to make it happen, it does take time. So for that reason, a nomination just allows instant release of funds from the banks. Your demat accounts can be transferred into another name, etc. And then within the family, you can divide it in the manner it is supposed to be divided. And assuming, God forbid, there isn't an agreement to divide it in the manner it should be, then the courts are always there to ensure that it goes in the manner that it's willed or by natural succession meant to go.
Thank you. Thank you for that. That is very helpful because this is a very routine query that we have seen asking clients, litigants, they're across the newspaper about why should nominations be made? What is the relevance? And is it really required if I've given something to a particular person in my will? The next question, and I think this is perhaps one of the most important ones that we keep hearing from people is, what is a good will and how do I make my will a good will? If I could invite Justice Endlaw to perhaps elucidate our viewers on that.
A will is made generally for two reasons, either to interfere with the natural succession, what the law provides, how your asset will be divided, or if there are several assets, then to distribute the assets so that the children or the legal heirs do not fight over it. Because a lot of times what happens, if there are 5 assets and 3 heirs, the disputes arise that who will get what. And they are unable to divide, and ultimately the matter ends up in the court. Not only does the family lose a lot of money in litigation and in litigation expenses, but there is a lot of heartburn. It spoils the filial relations further. And the worst part is the property is wasted. Till now, we were fortunate in Delhi, at least, that the property prices were appreciating the real estate. But now we are seeing a contrary trend. So it should not be that a property which is worth substantially more is reduced in price just because a litigation was going on. The same applies more to other kind of assets, as Akshay spoke, particularly the shares, where the valuation differs. So there is a right time to get rid of the shares. But if there is a dispute, so these are the two reasons for making the will. Sorry, what was the question again? I'm sorry, I missed it in the context.
This is helpful. My question specifically was how should one be satisfied that I have made a will?
Yes. So the purpose is to simplify things and to avoid disputes. But what we see in a large number of cases is that people forget that what is the purpose of making a will. They make such a complicated will that it leads to disputes rather than resolving the disputes amongst the heirs. So now I'll tell you what kind of complexities people. There is a general desire, what we see in the parents or the male or the female, that I should bequeath my property so that all my children remain joint. They stay together, they don't go away. So you have to see that you should not be imposing upon them. If they decide to, well and good, it's for them, but it should not be imposed by way of a will. So it should be a clear-cut division of properties and in very simple language instead of using a very complicated language. And the thumb rule is the thought process should be to ensure that there are no disputes among the heirs and then of course one has to take a personal decision that a lot of times if it is given to the spouse, certain restrictions are placed on the spouse, how it is to be done. And once you follow that principle, then I think rest falls automatically in place, because the circumstances may differ from time to time. If we have time, I always give the best will I have seen. I always give an example of that. That was of an industrial family, and the patriarch divided the businesses amongst the sons. And the beauty of it was that they were, of course, corporations. So he gave 60%, and they were aligned businesses. So that fear was there in his mind that the children may start competing against each other, and they may outbid each other in the contracts. So what he did was he gave different units 60% shareholding to, say, if there are 3 sons, to each of the 3 sons. Then he gave 10% to the other 2, or let's take an example of 4 sons. See, that was a case of 4 sons. So 10%, sorry, not 10%, he gave not 60%. Then the idea was that the son to whom a particular unit was given had majority shareholding in it, could take all decisions. Each of the other sons had a 10% share in it, so that he also had a substantial stake, and his wife had 10% of each. So, and the wife also made a will on the same day, bequeathing that 10% of hers again equally. So at the end of the day, after both the parents, each son knew that he is going to end up having about 12 to 13% stake in my brother's asset also. So he also wanted to keep the share prices up. He didn't want that company to go down because that was a substantial thing. And I had an occasion to see that will in operation, and it worked very well for that family. So I'm just giving this as an example that how you have to devise that that disputes don't happen. Only because of this, the disputes didn't happen. The brothers didn't compete with each other. They did not fight with each other. Each one was happy. Of course, the division was equitable. When he divided the 4 units, 4, 5, whatever, he divided them value-wise equally. So the family remained joint, and though he had separated all of them, but they remained joint to see that the entire business of the family continued to do well, because if they had a stake not only in their asset but in the brother's asset also. So that should be the thought process while making a will.
I think that's a very interesting case context that you've given us, that with the objective of keeping the family joined, the will was structured to achieve that objective, and like you said, the objective was achieved very well. In the same context, I think one dispute which we hear of, and I think is still pending in courts, is the Birla Lodha will estate. And that brings to us the concept of a life estate. So if the panelists, if the two of you could talk to us about what is the concept of a life estate in a particular person, why is it important, and what should one really look out for to not, for lack of a better word, if I may say, to not land up in a dispute like the one that I just mentioned.
Akshay, you go ahead.
See, life estates are actually a very, very complex issue, and what I would say as a panelist here, as far as possible, avoid it. Your wills in general should be simple, bequeathing the property to the person you intend for it to go to. Do not try and overthink the issue as to where do I want it to ultimately land up. Leave it to the wisdom of the people who you're bequeathing the asset to. So if you're bequeathing it to your wife, do not try and put too much fetters on her to use the will. Or if you're bequeathing it to a son, don't think about how it will reach your grandson. So give it to the person. Don't put these fetters on the person who's receiving the asset, so that they can deal with it in a proper manner. Now, coming to life estates, there are multiple ways. One is when a life estate is given to a wife because of her pre-existing right to maintenance. That creates a different kind of problem in law, because there is a deemed fiction by which that property becomes her absolute property. So again, having said that, it all depends on the facts of the case, whether it was a case of when the property was given as maintenance, or was it an absolute bequest? Because where it is an absolute bequest, then of course you can give a life estate and it will remain to be a life estate. Then there is a third concept with what you mentioned, the Birla Lodha thing, that arises out of a concept known as mutual wills. Mutual wills are really when a husband and wife kind of enter into an agreement, so to say, where they make reciprocal bequests to each other. And the concept of a mutual bequest is that the surviving spouse then cannot change the will. So that is a fetter that gets put, because the husband and wife jointly agree the manner in which the property is to go after both of them. And then the surviving spouse will not be able to change the will later. So all these scenarios come into play. But having said that, again, I mean, as a general opinion, as far as possible, do not get into the concept of life estates unless it is absolutely essential for you to do so. So would you like to add to that?
Yeah, just a couple of things. See, the problem, as Akshay said, with life estate is that it invariably leads to litigation, or at least we have seen the cases where it leads to litigation. Now, the problems arise because when the Hindu Succession Act was drafted, there were some earlier laws which vested women with limited right in the property. So even if they inherited a share, they inherited only a limited right. They were not. So in 1956, because of the earlier laws, there were a lot of such women who were having a limited estate. So the thought process of the legislature was that their limited right should be made an absolute right. So they incorporated a provision in the Hindu Succession Act about conversion of that limited right which the widow had inherited into an absolute right, or a woman had inherited into an absolute right. Now, there were two riders which were placed to it, that one rider that should have been against her pre-existing right. So if a wife had a right of maintenance against her husband, then that became a contested question, whether the wife had a right of maintenance or not against the husband, whether she had a pre-existing right. And a lot of judgments. There are still some contradictory judgments on this, but the recent trend has been that even if in a will you have provided that it's a limited estate, it becomes the absolute estate. So this is one issue. Then the second issue about this is that you are restricting. If you say that I give the house or the money or everything to my wife, and after her I distribute it like this, you are in a way taking away her right to, as per the wife may live for another 20 years, 30 years. So you are not giving her full power to do as she feels, or to change it if the circumstances so demand. But why generally, I'll also tell you why people like to do it. Because another common thing which is seen is that, the spouses, limited estate is generally given to the spouse only. Very rare cases it is given to a unmarried daughter or a invalid child or something like that, who is unable to fend for himself or herself, and you don't want that somebody should take away the property. But in the context of spouses, one factor which becomes relevant is that a lot of times it is seen that the spouse, when left alone, tends to make a decision which may not be correct because of the weak state in which the spouse is left when alone. The balanced decision cannot be taken. So we have cases where, if suppose the lady is staying with one of the children, and naturally you will have disputes only with the people with whom you are living. So the lady will make a will that, all right, I'm excluding this and giving it to somebody who's staying far away. So to avoid that kind of a thing, people generally, when you come to lawyers, they say that even if you tell them that I don't want to give a life estate, it's not right to give a life estate, they say that, look, my wife or my husband may be prevailed upon by one of the children to the prejudice of all the other children, and I want to distribute it equally. So the vulnerability factor comes in, that the vulnerability of the surviving spouse. Generally, it is seen in old age. So we are not saying that it is an absolute no. You have to work it properly. And not only does the Hindu Succession Act create this, under the Indian Succession Act also, which would again be applicable across the board, there also what happens is that there are certain provisions that these are restrictive clauses. You cannot restrict the right of the heir or whosoever the property is being bequeathed to deal with the property as absolute owner indefinitely. So those rights and how it manifests in real life, that all right, you have given a life estate. Now, if it is desired to be sold, the asset, the heir will not give up. Let's take an example as Akshay gave, that, all right, I want the property to remain in the family. So I have given it to my son, and I have said after that to my grandson or granddaughter, and the third generation will be entitled to sell it. Now, all of them are willing to sell it, but they will not get a proper market price for it. So that is another way in which it manifests itself. Now, Birla Lodha, since you mentioned it, there, as Akshay said, it's a case of mutual. It's not a case of life estate. So there what happens that the law till now is that if the husband and wife have made an agreement that how the property jointly owned by them or individually owned by them, but they are collectively saying that after both of us it will be inherited like this, then the surviving spouse cannot change that. So that is the issue over there, that because the lady there, after the husband died, she felt that she had been abandoned by the larger family for whose benefit they had jointly agreed that the property should be given. So the thought was that, all right, she wanted to give it to people who were serving her absolutely. So those kind of things arise. Another factor about life estate is even if one of the child does not prevail, if the surviving spouse is living alone. So we have known of cases that where the will has been made, it's not forced, in favor of caregivers who may not even be an heir. So people want to avoid that also. A lot of people who have their children settled abroad who are living here alone, they don't want, so they make these kind of wills to ensure that the surviving spouse who is dependent upon a caregiver he or she may be very, very good, but in a weak moment there would be a possibility of saying that, all right, he is our actual child, he or she, our children are abroad. So that is another reason. So you can't doubt the reason of people to make a life estate or to give a restricted estate. You have to just see how best you can do the protection. Again, it depends upon the circumstances of each individual. There can be no general thumb rule about it. Thank you.
Thank you, sir. That is very helpful to understand the entire concept of both mutual wills and life estate. On that note, I think one impression which a layman, in India carries is that if I have written a will, why is it that someone can dispute it? I've written a will, I've got it registered, I have 2 witnesses, it's all okay, it's as per the law, but why is it that someone can take me to court and then dispute it? So perhaps if you could talk to our audience about that, and also elaborate on when a person actually wants to, let us say, exclude a family member from the estate or make a disproportionate bequest. Would a family arrangement be a better way to do it? Because that will have a participative process involved, and that could be perhaps some evidence at the stage of a dispute. But the first question first, which is, how do we convince people that you've done everything that you could, which is right, but why are you in court?
Yeah, okay.
On a lighter note, the answer to that is ingenuity of lawyers. So, see, the problem is, if a bequest, say, is not equitable, that is probably a classic scenario where a will tends to get challenged, where it is in favor of one child, or maybe excluding one child in favor of the other children. So, as far as possible, try and make your bequests equitable. Register the will, because what that does is, at least it takes out of the equation the fact that the will is genuinely executed. Because there are various factors on which a will can be challenged. Execution is one of them. So if it is a registered will, at least to the extent of execution, you are taking that doubt out of the mind. But a will can still be challenged, even though it is registered, on competence or undue influence, coercion, and various other factors that can come into play. Now, those factors, frankly, cannot be ruled out. No matter how perfect a will you make, if there is a likelihood of a dispute amongst your legal heirs, there is not much you can do to prevent it. All you can do is try and make it equitable, register the will, have witnesses in place who should always be younger than you, who will outlive you to prove your will if it is required. And if possible, have a doctor witness it or confirm that you're of sound mind, and take these sort of precautions to ensure that if a challenge does come about, then at least your will can withstand that challenge. But for me to say that there is a foolproof way of doing it, that there is no challenge, I'm sorry, I can't give that assurance.
Yeah, if I may just add, see, Renu, you mentioned about family arrangement. Now, family arrangement is a concept in law where uh, several people own one asset or several assets for them to divide that between them. When we are talking in the context of a will, we are assuming that the family doesn't have a right in that asset. So it is one individual who has the asset, and so there can be no family arrangement in law because you cannot be privy to division. That would only be a gift or something. So the family arrangement is ruled out. But there is a concept in law of an open will. So you can have a document which you have told all your children that, look, this is how I am making my will, and ask your children to witness the document or admit that they have been told about it on a separate paper or at the foot of the will or somewhere. But again, from experience, I have not known of, I think rarely one or two times where people are willing to make an open will, because that starts the disputes invariably, or at least the apprehension is there that the dispute which may happen after my demise will start today. Because even if you are doing it equitably, uh, uh, your equity is not my equity. So what I think is equitable may not sound like equitable to you. So those kind of problems arise, and disputes happen because again, for the same reason that if one of the children produces a will that, look, the father has left this will. Now, if the other children feel that, no, father always told me, a lot of times in the family we say, ye to tera hai, ye to I'll leave this to you, you look after this. And ultimately in the will, so a doubt arises in the mind that there is something wrong. This document has been fabricated by my sibling for his benefit. The father always loved me more. So the spouse may feel that he always said that it's of each other. So where is the question of this? So the spouse may challenge, or one of the children along with the spouse may challenge. So these are the things. Now the law prescribes a method of making a will. So that's where the scope of dispute comes, because the requirement is that it should be signed by the person, and it should be attested by two witnesses, and the two witnesses should have seen the person signing, and the witnesses also should have signed in his presence and in the presence of each other. So all these, if it is disputed, all these requirements have to be satisfied. Now, proof of that takes time. The courts are burdened. It may seem that if these are the only 3 or 4 elements which are required to be proved, it should not take a very long time. But our legal system is devised to eliminate human error. So if at one stage a judge has committed a mistake, we give a second chance of appeal, we give a third chance of another appeal, then of course the Supreme Court is there. So all that process takes time. And another problem which we have, the registration is one option. Nowadays, a lot of people have started having it videographed. But the problem which is arising, which is most commonly seen, is that we don't have a system of depositing a will. So, people don't know what to do with the will. Okay, they have made a will, they have created a video, they have created everything. So where to lodge it so that ultimately it can be taken out when the need arises. So people either keep it with a confidant. That confidant again should be a neutral person. It should not be that you keep it with a person who's favorable to a child whom you are eliminating, so he'll never give it then. So the witnesses don't like to depose in favor of or against a heir, so they may say, I'm not coming forward. these kind of problems arise. A lot of time, genuine mistakes happen that the witness may not depose correctly. Over a period of time, you lose what exactly had happened. So you make an error and somebody else can take advantage of it. So there is a strong need which this kind of organization before which we are today, maybe they can make a beginning with their employees, or Mr. Sopti just told us that there is a large participation, a provision, a kind of a depository for people to deposit their wills. And in public sector enterprises, the benefit is that you come to know of the demise of the employee immediately because of the connection which remains. So at that time itself, there should be a search that is there a will of this person, has he deposited anything? If so, then forward it to the, so that will add a lot of what we have seen people feel difficulty, that can be eliminated, and this can just be a beginning. Once scope makes such a beginning, maybe the next step can be the government can have a registry or depository, not a registry, we have a registrar. So some thought needs to be given to that also, because that is a gray area which people are finding difficult. We have Mr. Sopti.
I think
Thank
it's
you.
a very innovative suggestion of having a depository with the employer, and particularly in the government sector. And I'm sure Mr. Sopti can perhaps take more suggestions from Justice Enlaw on this issue and implement it, because I see a lot of merit in it. People are caught up in situations where they feel, okay, we've written a will, where should we keep it? How should we safe lock it? Should we put it in a locker in a bank? What should we do about it? So these are the ground reality issues that we're facing, and I think the suggestion is very
most of the time people just leave it in a cupboard which they think will definitely be opened after me. And if it is unfortunately opened by somebody who doesn't like the will, then there it goes. The others don't.
The will can be destroyed if it gets into the wrong hands.
Precisely.
It's a very, very good suggestion, sir. I mean, I think there should be a system where people can deposit the will. So at least to a limited extent, the challenge can be, at least mitigated, I would say, not completely eliminated, but at least mitigated.
And if the deposit is through the employer or through an organization like Scope, then that will also add genuineness to the document that
Absolutely.
nobody else could have won. But it is possible only for this kind of an organization. A central registry, often this subject in one or two other platforms has been debated. The thing is, how do you come to know? Either we link it to registrar of deaths and births, but that also is not everything is reported in our country. And when we are talking, maybe in a city like Delhi, it can be done. But across the country, it's still a little challenging thing. And since we are on this, another common problem, which arises is that it's very difficult to find witnesses. It's easier said than done to get some relatives or friends to witness. Nobody, because people fear this, that I'll have to come to the court or I'll be seen as partisan. They say that a lot of times the children cost the witnesses and say, you knew about it, you never told me.
You're right, so confidentiality becomes an issue for witnesses also, because especially in a case where the parents are not disclosing the will or the contents of the will, then for the witness also to be completely quiet about it, especially when it is a family member, all these things do become an issue.
Sir, I was seeing a question also in Q&A that whether witnesses are must for any will.
Witnesses are a must.
Okay.
All right. Thank you so much for that discussion. Moving on, I think if I could request the panelists to talk about principles of testamentary succession in Muslim law. What is it that would be different if at all, from principles of testamentary succession in Hindu law? If you could touch upon that, please.
See, Muslim law is not codified at all. It is basically governed by Sharia law. And there is a concept in Muslim law that you cannot bequeath more than 1/3 of your property. The balance has to go by interstate succession, and the line of succession in Muslim law is quite actually complicated. It would require an entire webinar for us to be able to put that on record. So to put it very simply, in Muslim law, you can only bequeath 1/3 of your share. The rest will go by interstate succession. That is customary law. There is an exception that where you could bequeath your entire estate, but for that, all your legal heirs have to accept it. Now, practically, I don't know how far that may be possible because the line of succession is quite vast in Muslim law. So to get everybody to agree for the succession to go in a particular manner would be practically quite difficult. So that fetter of 1/3 would remain. The question, in fact, Mr. Sopti just asked about witnessing. In fact, in Muslim law, there is that exception that you don't even require a witness. In Muslim law, you can have even a letter as long as it clearly spells out the intention of the testator would be a valid will. And courts have even held oral wills in Muslim law to be valid wills, provided it can be proved substantially that that was the intention of the testator. So that is the primary distinction between Muslim law and Hindu law or Indian Succession Act. And again, while having said that, I would just like to point out that in case of intercaste marriage, which are registered under the Special Marriage Act, or even if Muslims marry under the Special Marriage Act, then the customary law does not apply. Then the Indian Succession Act will apply, and then you would be able to bequeath your entire estate, irrespective of the customary law.
I'll share a secret with you. As a lawyer, whenever I was dealing with a case of intestate succession relating to Muslims, what I followed instead of studying it, they have a system of a Maulvi issuing a fatwa. He'll give you the inheritance after studying the family. So we always requested the clients to get that fatwa, and they have some very learned Maulvis, so they would also write which provision, under which provision this share. And that was generally accepted. And on the bench, I don't think I have in 14 years I have had any occasion to deal. So the good part is that it seems that that section of the society is not litigating too much over it. So that way they are better.
I think that is absolutely wonderful. Moving on from wills to, I think now we are going to cover the topic on guardianship and how to guardianship nomination. Some of it we have already covered during the course of the questions. But what would your suggestions be on how to look after minor children? We've all seen in COVID-19, there are people who've lost both parents, there are children who've lost both parents, there are children who've lost one parent. There are messages being circulated, not authenticated, where some children are being put up for adoption, which is definitely not a legal way of doing it. So your suggestions on how to provide for minor children in a will?
Say a minor under the law has a designated guardian. So it's not as if you don't make any provision, a minor is left without a guardian. So, but when you are mentioning these cases, these are cases. So the guardianship then under the law falls, they would say primarily the father. Now that is being interpreted more as mother also. In earlier times, all the judgments were the father has the first right. So then the mother, then the grandparents, or an elder sibling if the elder sibling is there, and so on. And if there is no one, then the court is the guardian. The court exercises the jurisdiction of parents patriae, that of all children, in fact, even if the father is there, but the superior right is of the court to see that the interest of the minor is safeguarded. Now, what happens when you are making a will? Again, you have to find if you have a minor child, or we also take a child who's unable to, a special child who's unable to look after his or her affairs, to appoint a guardian. Now, that is another very, very challenging fact in our society, that people are facing a lot of difficulty on that. That problem is coming more and more to the court, because either there is nobody willing, for the close relatives also, it's a very, very arduous task to take to agree to be a guardian. So you will not have a person willing to take this on, and the doubts arise that even if you appoint somebody under your will as the guardian, whether that person will be good or not. In fact, I have known of lawyer families who are unable to find anybody fit enough to appoint as a guardian of a special child. But yes, in a will, a provision can be made, and it's more challenging. Say a minor per se by age would attain majority. But when we talk of a special child, the special child will live on a full life. So we are talking of that. So that aspect, again, everybody has to think. And there are always, then again, depending upon whom you are entrusting as guardian to provide certain, don't give a free right, put some fetters so that whosoever you appoint as a guardian, or maybe the best situation, I know it's impractical, is to have 2 or 3 people as joint so that the common goodwill remains, if that is possible. But as I said, it's difficult to find one. To think of 2 or 3 people is all the more difficult. And once you have appointed, then of course that person looks after the interest. One can provide that the sale you should provide, how it should be conducted. Ideally, it should be you form an estimate of what kind of a monthly outflow is required, give freedom for that, put a limit beyond that, anything, either court's approval or somebody else's approval, that kind of a system needs to be built. Anything else, Akshay, you would like to add?
Yes, sir. Just to add to what you were saying, that I mean, especially in case of children with special needs, you could also think of forming a trust, which you can make a trust as part of your will itself. Normally, when you have to create a trust, it is by a registered document, but there is an exception in case of wills that you can create a trust by way of a bequest itself. So that trust can be created as part of your will with detailed conditions as to how to deal with the assets. And like Sir was saying, it should provide for circumstances under which an asset can be sold, how the proceeds are to be utilized, invested, and if you can file, I mean, if you're creating a trust, you would have to find more than one trustee. So if you can have 3 of people at least over there, then then the decision-making process can probably be more neutral than when it is just one. But talking about the present situation where we have seen even young parents passing away. So in that case, people should today, when they are making their wills and they have minor children, at least name a guardian for their children. God forbid that they pass away when the children are still minors. Because, like I said, you can always change your will later and all that can be changed. But for the present, when you have minor children, I think given the current scenario and our mortalities as they are, one must give it a thought and name 1 or 2 alternate guardians, such in case one person is unable to take up the task when there is another person. In your family, it could be the grandparents, it could be your siblings, it could be anybody who you feel the child would be comfortable with and who would be willing to take it up, because it is a very onerous task to look after somebody else's child. Because it is, I would say, it's even probably more of a responsibility than your own children. So something one has to give thought to. Coming to the other question that Renu had put to us is about adoption. Now, recently, a few years back, the Juvenile Justice Act was amended to set up a full system of adoption. And a body was set up which is known as CARA. So all adoptions in India now have to go through CARA, especially in a case where both parents have passed. And for international adoptions, also CARA comes into the play. Under Hindu law, there is an exception, but for that, the parents have to be alive. They can, by a registered adoption deed, give a child in adoption to someone else. But we are not talking of that kind of a situation. So there is a body in place. If something like that has happened in your family, or if you are interested in adopting a child who is unfortunately in this situation, then one must go through the legal process, approach CARA, register as yourself as a prospective parent, and then they will find a child for you from the registered orphans with them. If you go directly, you will face many legal hurdles which you don't want to get.
Thank you very much for those answers. I think these are again a lot of regular queries that we are seeing people ask across forums. Before I think we're going to move to a Q&A section, and we're getting a lot of questions, and the team is filtering those questions now because some are asking the same topics. Just briefly, if we could touch upon the principles of succession where there is no will in Hindu law, very briefly, and I leave it to you to how brief and how elaborate you'd like it to be.
I think sir is the master of that. Let him answer that.
Absolutely, sir. Yeah.
It's interstate succession. The thumb rule amongst Hindus is that the mother of the male and the spouse, the wife, and the children all get equal share. Same about a female, that the husband and the children. Of course, the mother is eliminated. For women, there is an additional provision that if a property has been received by the female from her family and she doesn't leave any children, then it doesn't go to the husband. It reverts to the parents or to the parents' heirs, if suppose she has received from. So that is the only difference. And then, of course, there are further provisions that if one of the child is no more, then how it goes to his or her heirs. So that's how it gets divided. Now, the most one or two questions also I was seeing is about that. In the ancient Hindu law, there was a concept of co-parcenary. Now, that is what has posed a lot of confusion and thing about it. Now, in the co-parcenary, only the male lineal descendants had a share. For some strange reason, in 1956, when the law was codified about Hindu succession, that co-parcenary context was saved, that part of the ancient Hindu law. Otherwise, the Hindu Succession Act said that any property of a male, as I said, goes to all the children equally, whether a daughter or a son. Now, co-parcenary property was going to only the sons, not to the daughters. So that gave rise to a lot of litigation, and more because what we've seen in the courts is that it's not as if there were a lot of co-parcenaries, but the sons were refusing to give a share to their sister, saying that, believing that it's a co-parcenary. Co-parcenary, to say it very broadly, it could either be created by a declaration. A male could put his property that, all right, I am making it a co-parcenary property, which became, in which only his sons will have a share. Or it was a creature of law that if the male's father who had died prior to 1956, he had some property which had been there, which he had inherited from his ancestors. So there were very few cases of genuine co-partnership, but that was it was all very beneficial for us lawyers. So I think the lawyers have made a lot out of it, and a lot of cases got stuck. But then in 2005, this was changed. The legislature changed that, and they said that a daughter has an equal right in it. So that situation now prevails. So really speaking, the difference has now disappeared. The sons and the daughters have the same share. There is no difference. Agricultural law in Delhi, that we have struck it down in agricultural laws, because there are still some parts of agricultural land in Delhi. So with respect to the law again was that inheritance only by sons, because it was thought that only they will till the land. The daughter gets married and goes away. But I think more than 10, 15 years ago, that provision was struck down. But in other states, I'm not aware of the position. If it has not been struck down, then inheritance may again, with respect to agricultural property, be confined to the males only. So that needs to be taken up to be challenged. Anything else, actually?
So you covered it all. I mean, really, it is interstate succession is really fact dependent. So for us to give you an exact answer would be difficult, because it depends on what kind of line of succession we are talking about, whether this concept of co-partnership has to come in or not come in. Even in a direct line of succession, like Sir said, it could be a case where, supposing you had 3 sons and one son has predeceased the parent, then that line of succession has also opened. So there is sometimes a misconception that just because that line of succession has opened, and supposing the son has 2 children, they also get an equal share as to the brothers. But that's not the case. It's, it goes per stripe, as we call it in law. So if there are 3 brothers, it will be 3 shares. And if one of them is predeceased, his legal heirs will also take only that 1/3 share. It's not that their shares will increase and decrease according to someone passing away. Other than that, like I said, it all depends. The laws of succession are there, codified now under the Hindu Succession Act. And depending on your fact situation, it will have to be applied.
Thank you. I think this was a very good, quick snapshot of interstate succession. I don't think could have been better than that. I think we now have some questions from the audience. Samriddhi, should I start taking those questions, or is it?
Yes, ma'am. Foremost, thank you for a very informative session, Judge Endlaw and Senior Advocate and ma'am. Now, yes, ma'am, we are trying to filter the questions as much as we can. Yes, ma'am, we can start with the question answer session. And I'll just start with it by asking the basic difference that we are getting the question on between succession certificate and legal heir certificate. And then the ball is in your court, ma'am, to take more questions on wills and nominations.
Sure.
Over to you, ma'am.
I just take that question. There are actually 2 different things that have come into play now. A succession certificate is something that is granted by court. And now there is also something which has come up in the last few years, which is granted at the state government level, which is known as the surviving member certificate. So that is an added thing that has come up in the recent years, where after somebody passes away, you just apply to the SDM and he issues a certificate on the relevant paperwork being submitted, such as affidavits, etc., that these are the legal heirs of Mr. X. So that does not give any legal rights to property. It is only a certificate that is showing that these are the surviving members of the person. A succession certificate or letters of administration or probate is something which will eventually, on being granted, confer a right in the property which are subject matter of that will or in interstate succession. So that is the essential difference between something which is granted by court and a surviving member certificate.
Thank you. I think from the questions that we're getting, the first one, I would perhaps call it a politically incorrect question, but I would still ask that question because it is a very common question from people. Can a will be written without the help of a lawyer?
Yes, certainly. Now, see, one of the lawyers from my batch, he had written a book nearly 25 years back. The first book, as per my knowledge, How to Write Your Own Will. And it was such a roaring success that he gave up the profession and he became an author. So it was available at all the railway stations that Rowley, no, there used to be one bookstall which was common at all the railway stations. So, and a lot of the interesting thing is a lot of people used to purchase it while traveling. So I have personally seen a lot of people having that book while traveling in the train. So it can be done, of course. You have to just see those basics, follow the principle. And of course, if you feel, as I said in the beginning, the need for a will is because you have to take a call whether you want to make a will. So you will take a call whether to make a will or not by knowing who your heirs are. For that, if you need any legal assistance, you may. But otherwise, yes, you are absolutely right. The statement from this platform should be, no, everybody needs to consult a lawyer.
In fact, sir, there are now online sites and even banks as part of their services that are offering to write basic wills. So you can certainly do it on your own.
Yes, I think the next question is, who is an executor? What does it mean? And is an executor necessary to the will?
An executor is not necessary for a will. An executor is basically a person who will distribute the property amongst the legal heirs. So if there is no dispute, then the executor, of course, receives the property. But before that, the problem which arises, see, you asked about succession certificate, that why is it required? Now, if suppose there are monies in the bank, now there is no dispute amongst the legal heirs. There are two children and a spouse. They go and they say that so and so has died. We are the only legal heirs. This is the will. It has to go to the spouse. So please give it. But how does the bank know that there is no other legal heir? How does the bank know that this is the correct? This is actually the will of the deceased. Or even if there is no will, actually succession certificate is mostly in the case of without a will. That there are 4 heirs. The bank doesn't know their fifth one may turn up after 2 years, or a sixth one may come. So they require the court to certify that yes, the succession, the money has to be given to the certificate holder. So that is the genesis. A lot of banks have a policy. They say that if the amount is less than 50,000, they will not require a succession certificate. Some banks have a larger limit. So that kind of a thing. Then legal heirship certificate, what you mentioned earlier, see that is in vogue. It is available online, but there is still a question of that. What is the authenticity of it? Because it is given on the basis of the information which you feed in the computer, and you get a legal heir certificate. Though an inquiry should be made, but at least I am not aware of any inquiry which is being made before issuing it by the district magistrate. So that is why the need for these documents arise. Sorry, come again. What was the question? Does it cover it or?
It covers it. It covers it absolutely.
Yes.
The next question that we have, and I'm trying to sort of look at questions which have not been covered in the talk already. Are there any assets or properties that should not be mentioned in a will?
You can mention every asset that you have. In fact, you must mention every asset that you have. And in fact, in your will, you should have a residuary clause, what we call, where it says that if any asset is not specifically mentioned in the will, it would go in XYZ manner. Say you can even give it in terms of equal proportion, or set a percentage between your children or whoever you want to give it to. So that covers any asset. You may inadvertently miss, or you may acquire after making your will.
That's right.
Not somebody else's property.
I think with that, the one follow-up question from me is that we have often seen wills where people write ancestral property and not just their share of the ancestral property, but the entire property itself. So is that right? What should people, what are the pointers to keep in mind while bequeathing your share in ancestral property?
Say, one thing got missed out in the first question, so if I may deal with that first.
Yes,
that
please.
About
Yes.
Mentioning the properties. Now, today with the a large number of cases where children may not be living with you, they are not even aware what your assets are. So in fact, it becomes necessary to detail out the properties. And the comfort factor also is higher. If you may detail out the properties, anybody dealing with, even if it is a case of only one child, no spouse, anybody dealing with the child would be very confident of dealing with him with respect to that property once it's mentioned in the will. So, and if you don't want to mention it, then there should be a separate envelope made where you list out all the assets which are there, because it's possible that people don't know of it. In fact, in earlier times, again from personal experience, in the city area, there is a central bank over there, and they had a large number of safe deposit box which nobody was turning up for 15-20 years. And what I happened to speak to the manager, he said that the women used to make savings which they used to hide from their husband even. They would not disclose. So nobody would know of that safe deposit box. So once they passed away, they would give a fake address so that no letter goes of this. So they were having this problem. So they had come for legal opinion that what should be done, what procedure should be followed for that. This was typical to that area. And they said a lot of shopkeepers also used to, for a business eventuality, used to hide. So it's very important to give the particulars. Now, what you asked about ancestral property, the rule is what I said earlier, that even if you bequeath somebody else's property, that property will not go. So even if you have bequeathed more than your share, the will be read as relating to your share, except that it may raise another issue and the litigation may become longer.
I think the next question we have is it advisable to have a trust for children mentioned in the will where children are not minor, so of majority, but still young and of impressionable age? So if the children are 19, 20, 21, still going to college, is it advisable to have a trust for children?
See, this is something which would be very personal. So to give a general answer like that, whether you should or should not, is very difficult. There are both advantages and disadvantages to a trust. The advantage of a trust is that you have trustees in place who are helping your children manage the estate and all. The disadvantage is that that property is then not vesting in your legal heir. The moment you create a trust, the trust becomes the owner of the property. And your legal heir probably cannot deal with that property till that trust is dissolved. So, there are pros and cons of a trust, which one has to weigh. I mean, trusts are coming into vogue these days again, but it is a more complex system of holding than a direct holding for sure.
It can happen. We had a case where a very successful business, because of the condition imposed like this, that the son will get charged at 40 years of age. So the whole thing was wasted. Yes. Because the economy changed and the business required to be dealt in a certain way, which the son was not able to because of these kind of limitations. There also a trust was formed. Now, everybody has their own lives. the trustees, all right, they were very good. It's not as if there was any animosity, but they had their own businesses. They couldn't devote that much time to this business. So you have to assess the need, applying all those factors.
That's very helpful. The next question, I think this is interesting, is that if a person dies without writing a will, the principles of interstate succession will follow and it will go to his legal heirs. What happens to his liabilities? So do the liabilities also pass on just like the assets do to the legal heirs? This is the question that we have.
Yes. The liabilities have to be satisfied out of whatever has been inherited by the heirs.
The next question we have is, can properties in foreign countries be included in a will? Or is there any particular thing to keep in mind regarding that? Because this is also very common. I mean, people buying holiday homes in London, in zone 6 is perhaps cheaper than buying it in Delhi today, an apartment in Delhi. So another very ground situation, that if you have immovable assets abroad, can you, as an Indian resident, bequeath those through your will?
You can have a will for all your assets. It doesn't matter which jurisdiction you reside in or which jurisdiction your asset is in. The question that really will have to be seen is that would you be able to take a probate in India and then go and enforce that probate in a foreign jurisdiction? Or would you require extra steps to be taken in that foreign jurisdiction to give effect to that probate? So the question is really of how to give effect to the court orders or the probates, etc., that you receive in India. So as far as making the will is concerned, you can make a global will. There is no problem at all.
Thank you. Thank you.
It's better to make a separate will as a point of, like I'll give you an instance. I had a case where the man had made one will with respect to several properties, and 3 of which properties were residential houses, all leasehold. We are talking of earlier times and if you had one leasehold house, you couldn't take another.
Yes.
Somehow he had managed to. So when on the basis of that, they went for mutation to Land and Development Office, they started proceedings for cancellation of lease of the other 2 houses. So he should have made separate will. So if you have this kind of a issue, it's always better to do it separately.
Yes, in fact, as sir is saying, I mean, what you can do is that you can say that this will is for my assets in India only.
Right.
So
right.
that way you can have a separate will for your assets abroad, and then you can also proceed separately for each asset in that very jurisdiction.
You will save the inquiries in India also.
In fact, this was one of the questions, that can one make separate will for each asset? And I think that answers that question.
Yes, you can. You just have to make it very clear in your will as to what you're doing.
Yes, yes. I think the other question that we're getting from a lot of people is on what is the difference really between getting a will registered and getting a will probated. So if you could talk about that.
There are 2 different concepts. Registration is something which you do within your lifetime. When you execute a will, you go to the office of the sub-registrar along with your witnesses and you register the will. And that registration, as per the rules, are kept a secret. So for a person to apply for a copy of your will, they have to produce your death certificate. So that is the concept of registration. It is only to eliminate, as I had said earlier, the objection with regard to execution of the will. But a probate is something that you go to court after the person has passed away, asking the court to give its stamp of authenticity to the will. But, because you could require it in the case there is a dispute over the genuineness over the will amongst the legal heirs, or sometimes you just require it especially in cases of unregistered wills, because authorities are not accepting the unregistered will. So there you have to go and seek a probate or letters of administration from court, where the court, after going through the will and the steps, that means the witnesses have to depose on the authenticity of the will and all the requirements, will then grant the probate or letters of administration on which you can then act on the will. So they are completely two separate concepts.
Thank you for explaining that. One question, and probably, I mean, Samriddhi can tell us if we're running out of time, and this could be the last question, is in this entire paradigm of a will, creating a trust, or an open will, a family arrangement where everybody has an asset which is brought to the table, what would be the reason for somebody doing a gift during their lifetime? I mean, what are the benefits and what are the disadvantages of the same if you want a very clean process of your assets while you're still alive?
Executing a gift of a property, we are talking of immovable property, costs a lot of money in terms of stamp duty. So that is a big deterrent. So that is resorted to generally when the total value of the estate is far more and you are expecting a lot of challenge or a vehement challenge from one of the heirs or more heirs whom you are depriving of the property. Then the heir who is getting it all or who's getting it largely may say that, all right, might as well spend this money on stamp duty and take it in my lifetime. But there also the issues arise that if the donor is of an advanced stage, then it doesn't eliminate the challenge altogether. The question still arises that whether undue influence was used on the parent or whosoever is making the gift, the donor as we call it, to whether he made the will out of his own choice or he or she was prevailed upon to do that. So you cannot eliminate a challenge, but yes, to avoid future disputes, that is an option at a heavy cost.
Also, to add to that, the person making the gift must realize that he's losing complete control over the asset. A will comes into operation after he passes away. So during his lifetime, he has complete control over the asset. The moment he makes a gift, that asset no longer belongs to him. So that's another thing that the person has to keep in mind.
Now we have the Senior Citizens Act,
yes,
where it permits a challenge before the magistrate.
Yes. I think this legislation has been very useful in terms of protecting senior citizens, and I think the interpretation which Delhi High Court, some of the judgments have taken, have been very pro senior citizens in this legislation, which has been a very sort of advanced approach. I think one last question. It's a little specific. So, I mean, if you feel it's inappropriate, we can not take it. The question is, if one has made the will and no nomination is done by banks in the bank or demat depository or other institutions, will these institutions honor the will mandatorily and can it replace the nomination?
Yeah, please. No. Go ahead.
So, as I had said earlier, a nomination is not a bequest. It is only to take the money out of the bank. Now, supposing you have no nominations and you go to a bank, they will have their own set of requirements under which they will release the money to you. The problem many a times practically that arises is in cases of unregistered wills. Because as per most of the mandates that the banks have in their internal guidelines, they do not accept unregistered wills without a probate or letters of administration. In terms of registered wills, there is an RBI circular that requires the bank to accept the wills, provided all the legal heirs give a certificate accepting the will. So that if you have a registered will and you can get everybody's affidavits accepting the will, then the banks will release the money in terms of the will in spite of nominations or despite there being no nominations.
Thank you. And I think the last question is how do we, because I think Mr. Mukhija did say that you can change your will. And I think the question is, how do you change your will? So that's the last question.
Simply write a new will.
So here's the answer to that question. So
Overdoing the earlier one.
Yes, yes.
Or just tear it off.
Provided nobody else has had sight of it.
Yes.
Yes, ma'am. So thank you so much for a very, very engrossing session. I actually lost track of time myself. So apologies for that. But yes, we are still receiving questions, but we have to be sensitive to everyone's time. And I request the participants to please, you can put your questions to us in the emails shared with you, and we'll try to get it answered from the panelists and share with you back. But another request, please do not ask personal questions. We are getting a lot of questions that are very personal and typical in nature. So yes, please contact a lawyer for that. And we have 2 very good ones on the board. So now moving forward. So thank you, ma'am. Thank you, Judge Endlaw. Thank you, Mr. Mukhija. Thank you, ma'am, for the information shared and for being so candid about everything. Now moving forward, I request and I invite Shri Ratna Shekhar Adhika ji for his concluding remarks. Over to you, sir.
Yeah. Honorable Justice Rajiv Sahi Endla ji and Akshay Mukhija ji and Renu Gupta ji, Atul Sopti ji and Scope team and all the participants. It was really an intriguing session and intrinsic session also. This was actually the need of the hour, and then Scope did a wonderful job of picking up this topic and then putting luminaries. It is not that ordinary people who were sharing their thoughts on this. It was luminaries, and it was really great. It is indeed our pleasure to have this session. And if I have to quote Albert Einstein, it says, "Tell me and I will forget. Show me and I may not remember. Involve me and I will understand." This session exactly lived up to that expectation of Albert Einstein. All the participants, I could see from the numbers who have attended here, it was 320 plus at the beginning. And then at the last question, when Renu ma'am said that this could be the last question, till the time there are 300 people still glued to their screens. So that means this session is really lived up to that. And then it is an involvement session of the people. And then this was the need of the hour. And then thanks to the panelists who really gave their thoughts and then which guided us for many problems which we are facing currently. And the session started with basically how to write a will. And then it went on to other subjects which are connected to succession and all. And this example given by Justice Rajiv Sahi was excellent one, how to avoid disputes. And then that particular family business, wherein he made all people responsible for all the businesses and at the same time the spouse. So that was a great example, so that which can be followed by others, so that it will be no disputes will be arising out of these properties which you are going to pass on to your successors. Then there were variety of questions on minors, variety of topics which were deliberated, how you can take the guardianship, and then what specific Muslim law questions also were answered. And then it was really a great session, and then it was really good. Then the suggestion given by Justice Rajiv Sahi was excellent one. Really the digital technology, what public sectors are having, that how can we have a repository of wills? This is a $1 million suggestion which is given by Honorable Justice Sir, and then it is on our part to now examine this as a public sector community. And then I request Atul Sopti ji to take forward this through his other channels, and then see what best can be done at public sectors. It can be really done, and then it is not a big deal, but then we need to see the framework, how it can be carried out. And the questions were really answered aptly. And it was a real great informative session. And this was what I was told by Mr. Sopti sir is basically it is 25th webinar. And then it is on a Sunday morning, keeping people glued, 300 and odd people keeping glued to the screens is really a mammoth task. And then it was just possible because of the luminaries who addressed this session and then who shared their experiences. It was really worth. And I really thank Scope team and Renu Gupta madam for arranging such a great session. And I thank each one of you for sharing your thoughts. And to quote Ghalib, this is a very famous quote, but then it is very heart-touching for me. So I would like to just quote and close my speech. जिंदगी भर धूल साफ करता रहा गालिब, जिंदगी भर धूल साफ करता रहा गालिब, धूल चेहरे पे था पर आईना साफ कर रहा था, धूल चेहरे पे था पर आईना साफ कर रहा था. That means our effort should not be in a wrong direction, our effort should be in right direction, then things will fall in place. And thank you everyone, and thank you so much.
Thank you, sir. Taking the cue from what you said, sir, we should always move in the right direction. So with this, and thank you, sir, for encapsulating the entire session for us. It was indeed a very great summary. With this, we come to the end of today's webinar. We've been receiving requests for repeat view of this webinar and conducting more in this nature. So yes, we'll look into that and we'll certainly try to conduct more. And we've been joined by multiple families through our YouTube and Instagram sessions. And we have received a lot of questions there also. So Renu ma'am, we'll be summarizing everything and sending to you. So the list is crossed 60 already, despite of so many answered here. So thank you, ma'am, once again. And for the benefit of the participants, all SCOPE webinars can be viewed on our website and our Facebook page. So please visit our website and Facebook page for any recorded session that you would like to view. So thank you again, all the panelists, and I hope that we will be able to plan more vigilantly and in a much better way. I would once again like to convey heartfelt thanks from SCOPE and the participants to the esteemed panelists for today's enlightenment. We would also like to extend our gratitude to Honorable Justice for his guidance and for his candid conversation with us today. Thank you, sir. Thank you so much for your time and participating with us here. We also thank Senior Advocate Akshay Makhija ji for enlightening us with peculiarities of law and making it simple for us, though it is still complicated. But yes, we are really thankful to you, sir, for trying to simplify it for us and for your time, sir. We also thank Ma'am Renu Gupta for steering the session today and making it very seamless. Without your support and cooperation, ma'am, this webinar would not have been possible. So thank you so much, ma'am. And we are also grateful to Sri Ratna Shekhar Adhika ji for his time today and addressing us today. Thank you, sir. A big thank you to DG Scope for his meticulous guidance and roadmap. Thank you, sir, for always motivating us. Thank you to the Scope team for putting the webinar together. Last but not the least, gratitude to all the participating attendees for their enthusiastic participation and for putting in the questions, making it hard for us. But that was on a lighter note. But yes, we look forward to your questions and your requests. Thank you once again, and thank you for participating. Till we meet next again, please stay safe and thank you.
Thank you.